that we plan to elicit specific testimony from Dr. Pentagrossi and specific information from Dr. Logan. Because one is a pharmacologist and one is
Then I'm going to ask you to proffer to the court, to convince the court that it's not cumulative evidence, what the difference in your questioning will be to the two.
I would ask you to allow me the opportunity to review my notes and be able to answer this tomorrow morning. It's not going to change anything in terms of the court's ruling or change the schedule. Just afford me the opportunity to do my due diligence and not have to pop it off the top of my head.
But I will grant you that request as long as you understand that you are about to give an opening statement and call your first witness in
Over
this
my
case.
objection, yeah, I understand that. And I would like to say that yesterday, the state asked for, they ended early and we had no objection to that. Now there's a new ruling, evidence, now there's been additional motions, and I'm asking for the same leeway that the court gave the prosecution when they finished early yesterday to give it to me.
Okay. Well, this is a slightly different situation because yesterday we had all agreed to recess, and I had ordered the state and everybody else to have a witness available across the street. It just took us a lot longer to get our stuff up and running. So,
Well, Judge, then...
Okay, so proceed as you will.
I also need to lay the record. There was a situation yesterday. I wasn't afforded the opportunity because of the scheduling snafu. There was a point where Mr. Dunn, in his examination with one of the forensic, one of the videographers, shifted the burden. I filed a motion for mistrial. You reserved on it. I'd like to renew that motion at this time and move for a mistrial.
Okay.
Based on the prosecution's shifting of the burden, I'd also move for a mistrial based on the court's allowing the prosecution supposed to eliminate 3 weeks into trial, as I stated prior on the record, and not affording the opportunity to revisit my position and to adjust my opening statement.
Okay, respectfully, the motion will be, the motion for mistrial will be denied. First of all, the witness was not permitted to answer the question posed by the state of Florida, and the jury was given a curative reminding them that the burden of proof lies with the state of Florida. So that will respectfully be denied. Okay?
Judge, before we get on to Mr. Tisa's motion,
Yes.
I did just want to address the child hearsay from this morning.
Okay.
I spoke with Mr. Padilla, who provided me with some information that in fact his investigator was able to locate Mr. Vieira at the address that we had provided, that Mr. Vieira was less than cooperative, and so, Judge, while technically he is not unavailable, which means that Isabel is not unavailable, the state would be willing to concede and allow the defense to put in the deposition, to put in the video statement. They would have to do it by calling Mercy Restrani. It can't just come in. What I would ask in exchange for that sounds so bartery, but just is that since we're not going forward on the legal argument of the fact that in fact they are not unavailable, that the defense they can argue whatever they want about the video, but that they not be allowed to argue, look who brought the video forward. It was us and not the state.
Would the defense like to be heard on that?
We would concede as long as they put it in through Mercy Restrani.
Yeah, that's fine. That's fine.
Okay, so there we go, Judge.
Okay.
That's one less issue that we have to deal with, and I just thought I would take that off the table while we're dealing with stuff now.
Okay. So let's look at the motion on Tisa.
Yes, Judge, I don't think we attached a copy of his report to the motion, or did I?
Here.
No, not attached to
Judge,
what I
I'm
read.
passing up his report. Do you, defense? Mr. Zonganay, do you mind if I have give the court a copy of his report? Ben Tisa, we're moving on to that motion. Maybe Mr. Dunn's does. No notes? Okay, so give your copy. Okay. Thank you. Do you want Mr. Tisa's deposition off of this? It's relatively short, or no?
Let me hear your argument.
Yes, Judge, Mr. Tisa essentially did a couple of different things in this case. One, he tested a firearm which was similar make, model to the firearm used to kill Jennifer Alfonso, but it was not the same firearm. It was a brand new firearm, according to his deposition. So that raises a question right there with respect to the relevance of his testimony. to say that he fired a gun that was similar to the gun used is not the same thing and adds nothing probative to any issue with respect to the actual firearm. And I would note, Judge, that early in this case, the defense had made some mention about inspecting physical evidence, and that included the firearm. And the state was fully prepared, and there are procedures in place to allow expert witnesses hired by a defense to inspect evidence, including firearms, and that includes test firing of firearms if necessary. So it's not a situation where the actual gun would not have been made available to them. It would have, but they never asked for it. They went out instead and brought a gun that was not used in this crime, that has nothing to do with this crime, and that was brand new. And there can be no correlation or probative value with respect to Mr. Tisa's firing of a gun that was brand new versus the one that was not brand new and that was used in this case. Moreover, if you refer to Mr. Tisa's report, there are several occasions in which he makes statements which invade the province of the jury. For example, he makes references to Mr. Medina's, quote, perceived immediate and or imminent fear of his life or grievous bodily harm. That's
Can you
on
point me
page
to-
6.
Thank you.
Under the opinion section of his report, Your Honor, paragraph 1, it is my opinion that Derek Medina, based on immediate, perceived, and or imminent fear of his life or grievous bodily harm, could reasonably be capable of discharging 8 rounds of this gun in 3.8 seconds. Now, that statement is problematic on several levels. Number one, Mr. Tisa seems to be basing an opinion on what Mr. Medina can do based upon his own test firing of a gun. Clearly, that has no relevance or reliability. Number two, Mr. Tisa is purporting to give an opinion as to Mr. Medina's state of mind and whether he was in fear or imminent fear, and that invades the province of the jury. Mr. Tisa cannot be and is not qualified as an expert on what Derek Medina is thinking. He's not a psychologist. His actual diagnosis, or excuse me, his actual categorization on discovery was a, quote, use of force expert, unquote. So, and even if he were a psychologist, he could still, for the reasons cited in my motion, he would still not be able to opine and essentially to give an expert opinion that Mr. Medina was in fact in fear. The defense can't put expert testimony of that nature before the jury under the guise of it being an expert. The expert cannot invade the province of the jury, yet that's what Mr. Tisa is doing on a couple of different occasions. He does it on paragraph 1 on page 6, and he uses similar language on the following page at the top of page 7. He says, again, it is my opinion that Derek Medina, based on perceived immediate and or imminent fear of his life or grievous personal bodily harm, discharged 8 rounds in very close quarters. Once again, Mr. Tisa, the defense, cannot use him, call him an expert, and have him come in here and give an opinion which is essentially up to the jury to decide. So he has nothing relevant to offer because he didn't test the actual gun, and to the extent that he is offering an opinion on Mr. Medina's state of mind, he simply cannot do that. That's not permissible, and it should be excluded.
Defense, would you like to be heard?
Sure. The firearm, the testimony is that it's fully operable. Mr. Tisa fired similarly. I mean, this is something that Mr. Dunn could cross-examine him on towards the weight of his testimony, not the admissibility of it.
What about all of his opinions as to Mr. Medina based upon perceived immediate and or immediate fear of his life?
I'm sorry.
Okay, but let me finish my question. About those opinions, are you intending on eliciting that in his testimony?
Judge, first of all, this is a report he prepared for us. He was never deposed, so the prosecution never sat down and spoke.
Okay,
Sorry, he was.
that's
There's
fine.
a
Okay, go ahead, answer my question, though.
If he has an opinion as to the to what he's been qualified as an expert in, he absolutely can render that opinion. With regards to us giving him a preamble as to what our defense position is, that could shine light as to why he used that language. But if you want to instruct him that he can't make specific statements with regards to whether or not Derek was in fear, but if we can ask him a hypothetical, just like the prosecution asked, in a hypothetical where somebody's in a kitchen and we lay out what our defense position is, and then he can testify that in 3.8 seconds in combat situation, the the Versa 380 can be discharged fully, then he should absolutely be permitted to make that testimony, Judge. He's an expert. He trains FBI agents. He has a pedigree, a background, and he will be able to testify with regards to the specifics outlined. If you want us to instruct him not to use that language, then that's no problem.
But Judge, the fact that Mr. Tisa himself, a use of force expert, quote unquote, can discharge this gun within a certain period of time says absolutely nothing about the abilities of Derek Vernon Medina to discharge this firearm.
Okay, folks. Okay, this is what the court is going to do as to Mr. Tisa. The court will permit Mr. Tisa, is his title Mr.? I don't want to be disrespectful.
Yes.
Mr. Tisa to testify. Obviously, the matters of the fact that it's a different gun, not the weapon involved in this case, are ripe for cross-examination. However, the court will not permit Mr. Tisa to testify about opinions as expressed in his report about whether or not Mr. Medina had perceived immediate fear, or whether he was in imminent fear of his life or grievous bodily harm. The court will not permit him to testify as to other such statements that he opines that do invade the province of the jury. He will be able to testify as to what he did in this case, and then he will be permitted to answer hypotheticals that are based upon evidence that has been presented in this trial. Okay? Anything further on this issue?
No.
Okay. Okay, let's take 5 minutes, and then we will take opening statement from the defense.
I'm going to, once again, and I understand the court has ruled, but my client has asked me to ask the court for the courtesy of affording us the opportunity, based on today's rulings, the opportunity to open tomorrow morning as opposed to this afternoon.
You will be opening in 5 minutes. Thank you.